I'm doing this as both a video and an audio at the same time. And I'm doing it because I need to have a record at this point in time. First of all, let me say for the record, I absolutely do not approve of in any way, shape, or form the legalization of marijuana. I believe that it is actually part of a criminal conspiracy. And anybody that advocates for the legalization of marijuana, including as part of a long term process that has manipulated and disabused political opposition, is somebody that I believe should be investigated and held accountable for their culpability in a criminal conspiracy. Nonetheless, just because you are a member of an opposition political party, including one who may include members that are themselves members of organized criminal syndicates and or organizations and or may be attempting to engage in illegal activity in performance of their election campaigns with the intention of taking that with them into office should they be elected. That is no case for other people just by virtue of their assignment or association in a party affiliation. There's no justification for targeting them and using them in illicit processes connected to acts of retaliation. I believe something similar happened in 2008 when it was the election series or the election situation, and I was supporting a Green Party candidate for political office. I now believe and have for several months, even including and prior to the announcement about the mail in voting situation for this year's election, that Green Party candidates in the 2008 election were specifically and strategically targeted by Democratic Party candidates as part of some sort of secret litigious effort in an effort to bond them or engage them in acts of securities fraud to be used by Democrat that either got into office or that were running in election campaigns and intended to use that to support the Democratic Party. As a matter of fact, in early 2017, throughout most of the year 2017, I found numerous articles where people were challenging the electoral tactics that had been engaged by the Democratic Party during the 2008 election and how that impacted their individual organizations and their political activities outside of the campaign following the election of Barack Obama. That information is conveniently inaccessible and it has been for a very long time. There's a variety of information that was relevant to what would have been investigations concerning allegations of election interference in the 2008 presidential and other elections that was unavailable in the public realm until a very strategic point in time when I understood that the Republican members of Congress had taken up a new element of investigation concerning the alleged election interference in the 2016 election, i.e., there then became available online information about things that would have been relevant to an investigation of election interference in 2008 that had been obscured or obstructed in some manner for several years when I was trying to recover it for my own investigation. This is to say that there is large scale corruption involved in obstructing people's rights to due process and ordinary political process. It has been for a very long time. There's no reason and no justification for intentionally trafficking people for years, stealing their work products, stealing their political campaign ideas, cutting them off, interfering in their communications, including what would otherwise be an official communication with a colleague of theirs that may have been involved in election activity and or could have been involved in actual government functioning in a legitimate governmental structure, sabotaging their past work histories, misrepresenting their electronic accounts and identities associated with them in the public realm in order to serve the political purposes of particularized individuals who are culpable with criminal activity. I believe that the state of Texas engaged in an illicit action concerning the Libertarian Party in this past election sequence and cycle. There were several pieces of legislation that were, or several pieces of litigation that were submitted to the Supreme Court of Texas concerning allegations of election interference or fraudulent activity involving mail-in vote ballots, including one that was sent by the Office of the Attorney General specific to Harris County. But you have to understand, at that time in Harris County, there was also already declared to be a defensive engagement by a member of Congress, a freshman member of Congress who had military experience, concerning the fact that he had been targeted by China, in addition to other members of Congress, ostensibly because of improprieties. They had been sanctioned by China in performance of their government role. And I believe that he specifically and other members of the Republican Party in Texas co-conspired to engage in illicit and frivolous, if at best, criminal at worst, legal efforts involving the state of Texas and the Texas judiciary as part of whatever his strategy would have been in addressing the fact that he had been sanctioned by China. And this is what I mean: simulating military process in the course of an alleged civilian judicial process. Now, if I was running for political office and somebody tried to take me to court because they said that I had engaged in improprieties about attempting to get my name put on the ballot, and I witnessed what he did, I would call for a court martial. Now, I personally was not named in that particular suit. I was a witness, but it followed a pattern that I have been observing for years and have been trying to get some redress for myself. While my legal efforts have been stolen and have been disabused by others, including in some other form of judicial process that completely misses the mark on the actual charges that should have been filed and pursued, and instead allows for a variety of other derivative actions to be engaged that end up compromising the safety of their constituents. Specifically of concern is that there were 43 named respondents, and the information about how to contact them had been redacted as if it was a criminal filing. It was submitted to the Texas Supreme Court. The petitioners, that included both the parties and individuals who were named Republicans and in political office that were filing these charges, did not have their information redacted. It was only the respondents. Now, if members of the Libertarian Party co-conspired with these Republicans with an understanding that they may be able to leverage it to their long-term advantage, and or because they agreed to use it as some sort of covert ops scenario, well, unfortunately, what that ended up doing is it obstructed participation in due process for other people that were rightfully divested of their political rights during this last election season. And this is the second time in 2 years that the Texas Supreme Court has engaged in illegal activities in connection with partisanship in order to prevent and obstruct what should be charges in a criminal investigation, including of public corruption, in order to play some sort of politicization and abuse of the judicial process, while also doing a variety of things to compromise the safety of the people of Texas. Now, I'm very concerned because I know that they surveil my activities. And while they refuse to actually respond to me directly, including in manners that could cooperate with rightfully issued investigations or charges, I also understand a few other things. A, even if there are investigations that predate mine, I already know there are plenty of people you've already engaged in your investigative efforts and allowed to be considered collegially, if not just constitutionally, who are younger than me and came on board a lot later anyway. Because that's no justification. B, while I was in the other room yesterday, it's the first time I do that. Usually I do my legal work in this room. Why did I do it out there? Something's changed in the bandwidth recently. A lot of really good stuff that I've been working on ends up out there. So I did a review. A short time ago, I purchased this book, which is the official copy of the Federal Civil Judicial Procedure and Rules. It's from 2017. I will disclose that I have already understood that at this time that this was issued, I'm sorry, is this from 2017? What year is this from? I want to make sure. It's the 2017 revised edition. And at the time that this book was published, there is a committee assignment that lists as its chair the Honorable Neil M. Gorsuch. So as of October 1st of 2016, Neil M. Gorsuch was actually the chair of the Advisory Committee on Appellate Rules. I disclose this because I've attempted to contact and petition the Supreme Court of the United States in another matter in 2017, and I specifically filed a motion requesting the recusal of Justice Gorsuch because of potential conflict of interest in terms of what would end up coming up. In the last 2 months, I have said I would be willing to retract or withdraw that request for his recusal with an understanding that I still believe the conflict of interest persists, but that with a direct acknowledgement of what entails that conflict of interest, that it may actually be pertinent and it may be materially relevant to the proceeding, that rather than recuse himself, that there be some other exercise of judicial process that would understand what the specific concern was in the course of permitting for him to be involved in a proceeding wherein factors concerning his confirmation were materially relevant to what would be considered evidentiary. But I mentioned that because I was reviewing this, and while I was reviewing this, within the course of about 40 minutes, I came up with my appeal. And I am very concerned that based on the cryptos they got running, that they said today there was a deadline. Is that another deadline where the Attorney General of Texas, in abuse of his position, along with other people in abuse of their position, are using my legal efforts while they're obstructing my communications in order to finance their acts of securities fraud masquerading as if it is actually legitimately engaging the judicial process? Did they observe and or spy on me while I was coming up with my own appeal? Did they spy on my email when I was checking my own email and my own evidence in order to correlate and coordinate timeframes? Did they place some other bet or some other hedge on what they were going to isolate me in performance of my attempt again to try to seek due process so that they could, what? Present some other case that's not relevant to the actual material factors and use my work and put it under somebody else's identity? Because that's the accusation. And not only have they done it, but members of the federal district court system have done it. Members of the state Supreme Court and the state court system have done it. If you are a lawyer and you have a bar membership and you are licensed to practice law, or you are presumably legitimately elected to public office, what good does it do you to kidnap a woman and exploit her for years while you file charges that are completely frivolous in comparison with the gravity of the matter at hand? I understand you have to aggregate, you have to accrue, but in the course of making these diversions and engaging yourself in these crimes, you prevent yourself from having the political capital necessary or even the actual work product necessary to actually get the case substantiated. I've been watching for years while all you do is set up inferior quality in terms of what we actually need, and then what do you do with it later? You use it for all kinds of other things that are not about acquiring any sort of justice for your people and don't actually get the job done. It is completely unacceptable that we're in a situation where right now that appropriations for the Health and Human Services Department have defaulted while everybody's running a smokescreen right now, and the Republicans are trying to present frivolous litigation that's already coded to sabotage political opposition. I am over 10 years in. I am over 10 years into a strategic effort of political opposition to exploit me for their gain, and it seems like all that happened is when I went to people on the other side of the aisle in order to be honest about information I had that might have potentially had an impact on their credibility as a political candidate, they just decided to swap. They just took over the bond and decided they would traffic me and they would exploit me instead. It's completely unacceptable. This is not just an impeachment, or this is not just a challenge against the legitimacy of Joseph Biden. If you have a problem with Joseph Biden being president, what did you do in 2018? What did you do in 2016? Because the same stuff that's going on now is the same stuff that was going on then. And unfortunately, by and large, it's the same people that are promoting themselves as being authorities in refusing to get to the point. Now, some of the people that are on this Republican effort were not elected when I first went to members of the Republican Party directly and in person and told them I had information. But they have very similar benchmarks to the ones I would have had if I had been able to instantiate. Right? So let me say right now, I have a substantial appeal. I'm not ready to file it yet. If I catch any of you pulling any of these codes or any of the arguments I came up with yesterday, I'm going to have you disbarred and I'm going to have you arrested. You understand? This has gone on far enough.